Hi, welcome back to our channel. Today we're going to talk about why you should not quitclaim your children onto the deed to your primary residence. We'll start off with what a quitclaim deed is. Think about when you go grocery shopping. You go to Walmart and you purchase $20 worth of goods, and in return you get a receipt that verifies that you made the purchase of those goods and now you own them. Walmart will let you out of the store, no one's going to come tackle you. Well, in real estate, instead of a receipt, you get what's called a deed. It's kind of like with your vehicles where you get a title. So with the deed, there's varying types of deeds, but we're talking about a quitclaim deed, which is commonly used when families are using real estate transfers to transfer around property ownership. One example of when a family might use a quitclaim deed is, let's say that before I got married, I owned a home. Then I get married and now I want my husband to be a joint owner of the home with me. So I might do a quitclaim deed from Kristen herself to Kristen and Sean as joint owners. So now my husband and I both equally own the home as far as the deed purposes go. In this same situation, we'll take a mythical couple. We'll call them Joe and Jan. Joe and Jan own their home and they are thinking about inheritance for their son, Robert. They want to make sure that Robert can inherit their home without going to probate. So they come into my office and they say, how about we do a quitclaim deed from Joe and Jan, who are mom and dad, to Joe, Jan, and Robert. Well, I'm going to go over 3 reasons I discourage doing this. The first reason would be that now Robert is now a joint owner on the home. So let's say Robert decides to be a stinker and he wants to try to kick mom and dad out of the house, or charge mom and dad rent for living in a home that is his, or do renovations or destructions to the home that mom and dad did not approve of. It's going to cause mom and dad a lot of headaches because Robert is now a joint owner with them on the property and technically has legal say-so in what happens to the home. So that's reason number 1. I discourage people from quitclaiming their homes from themselves to themselves and their children. Reason number 2. Let's say Robert's not a stinker, because let's face it, generally if parents are thinking about leaving their kids and adding them onto their home, hopefully the kids have been very kind and fair to mom and dad and wouldn't do something along the lines of what I described in scenario 1. But if Robert has creditors, creditors can now attach a lien to mom and dad's house because Robert is now a legal owner of that home, which means creditors can attach a legal lien claim to mom and dad's house. So that's reason number 2, not to add your son or daughter or multiple children onto your home as joint owners with you. The third reason is actually a happy reason. At least we're going to finish on a positive note. We're going to talk about taxes, everyone's favorite topic, but we're going to talk about basis. So let's use a ridiculous example to make math easy. Joe and Jan purchased their home for $100,000 back in 1970. And now, 50 years later, the house is now worth $1 million. Well, they're going to pay capital gains tax on that home if they sell it, on that $900,000 increase in value in their home. We're talking about more than $100,000 in taxes. But let's say mom and dad pass away, they still own the home, and then Robert is going to inherit that house. Well, when the IRS is considering about whether or not to tax somebody for capital gains, they're looking at what that person's basis is. Remember, mom and dad's basis was the $100,000, what they paid for the home. When you inherit the house, you inherit it at the date of death value of the home for the second or last owner to pass away. So when Joe and Jan pass away in 2020, owning the home that's worth $1 million, Robert's basis is $1 million. So he could turn around and sell the home and pay 0 in capital gains tax. But if we were to quitclaim to Robert from, again, mom and dad, Joe and Jan, to Joe, Jan, and Robert, mom, dad, and son in 2020, and then they pass away, and then Robert wants to sell the house. Well, he is no longer getting away from those capital gains tax savings because Robert's value in the home, his basis, is all the way back to that $100,000 when mom and dad purchased the home. So you can see how there's a really positive capital gains tax advantage to letting somebody inherit the home as opposed to quitclaiming the deed to add your child onto it. All of this comes from parents wanting to come into my office to do probate avoidance. For more information on what probate is, when you need one, and all the things you need to know, check out over here our Probates Basics video that goes into that in detail. But thanks for watching. Don't forget to like and subscribe.